Welcome to our second lecture covering the topic of privacy in the employment situation. We're still concentrating in this first part of the second lecture on government employment, and so we're talking about constitutional issues. And we were discussing the Fifth and 14th Amendment due process protections, and we talked about how the strict scrutiny and rational basis tests can apply. To a due process type situations. And we talked about how the real issue turns on, is it a fundamental right? And if it's a fundamental right, this strict scrutiny is likely to apply. Now, we said before that, and we saw it with our own eyes, that neither the Fourth or the Fifth or any other of the constitutional amendments actually talks about privacy. But what the court will call the approach that our founding fathers had to the topic of privacy is that they talked around it. And it seemed that they did care about privacy. It's just that they were focused on discrete examples of privacy instead of stating the overarching principle. And so, what the U.S. Supreme Court found, started finding in Griswold and continued to find in other decisions, including Roe v. Wade, is that yes, there is a constitutional right to privacy. Again, not all constitutional scholars agree with this interpretation, but it is certainly the current understanding of the law that we have with the Supreme Court as we have today. And the concept that they use to discuss that is called penumbra. This is the word, but let me show you what penumbra looks like in the world of physics. This may help a little bit for folks who are struggling to understand this. And this is how a penumbra works. And you can see here, it's the shadow that's caught, that a particular item casts. And you can see here that because the light source is wider than the pencil, the light is coming around this way and on the other side of the pencil this way. And so you can see here the light is going this way and going this way because, of course, light goes out in all directions. And so there's this very, very dark area, which is called the umbra. And you can see it's similar to the word umbrella, which, of course, protects us from rain. Well, this is protecting us from the light. And then the part that is partially hidden and is called the penumbra. And so when we say that this idea of privacy is in the penumbra, it's the concession by the U.S. Supreme Court that no, it's not exactly in the Supreme Court. I mean, it's not exactly in the Constitution, but that notion is present even if it's in a different form. And so that might help you remember kind of how privacy is treated by the U.S. Supreme Court in constitutional matters. Here we go on. And so now we're going to talk about statutory issues. When we're talking about statutory issues, we're going to be talking about government employment and private employment. So from here on out, the special part about government employment is no longer, we're not just talking about government employment, unless I say that we're just talking about government employment for a particular section. The first part has been about government employment, and now we're segueing to statutory laws that usually apply to both private and public employment. And I've identified a few laws that I want to pay particular attention to. One is Ficra, the Fair Credit Reporting Act. And this is a law that requires that applicants and employees know if their employer obtains certain information about them, especially information about creditworthiness and criminal background checks. Ficra applies in lots of different situations outside of the employment context. It's a very broad law covering lots of different categories. But one of its areas that it covers is when the employer gets information about an employee. Perhaps the employer is using that information to decide whether to hire someone or perhaps whether to promote someone. Another law, which isn't directly applicable to our topic, but is applicable to you as a student and me as an instructor, is FERPA. This is the Family Education Rights and Pregnancy Act. And this has to do with what records relating to a student or how those records need to be handled by this school, including colleges. And so this isn't directly related to employment. It is relevant, I guess, to what we're doing right now, being in school. So I also highlighted these two statutes. This is the Electronic Communications Privacy Act. We'll talk more about this in later sessions, but the thing that I want to focus on here is that this act prohibits the receiving of wire communications, including email and voicemail. Now, this may sound like, well, gosh, I thought employers did this all the time. They do. There's ways around this. I don't know. I'm going to make it sound like that it was intended that there be exceptions to this. There's nothing underhanded going on when employers choose to uh, apply one of the exceptions to this. We'll talk more about this particular statute later on in this series of lectures, although not in this particular lecture. Then we also have the Privacy for Consumers and Workers Act, and this has to do with uh, the monitoring of workplace communications. The employer has to give a prior notice to employees. Remember, I talked before about that notice that may appear on your screen about once a year. Well, this is the reason for it. Well, this is one of the reasons for it, but it is also used again for diminishing the scope of the reasonable expectation of privacy. Excuse me. Not going to talk about this particular statute, but let's consider this scenario. So Bob works for a police department, so he has access to some confidential records. His brother is running for political office. Bob starts wiretapping to hopefully funnel to Larry some ideas about what would be successful campaign strategies. Under this situation, Bob has clearly violated the law because you can't intercept messages for political reasons. Eavesdropping. I already used this word a couple times. If you haven't heard it before, um, here is the definition again. The eave on a window is, you imagine, where somebody is listening in on, dropping in on the eave. So they're outside of the room or outside of the building, but they're still able to hear a little bit of what's going on. That's literally what this term means. Nowadays, we use it to cover many situations that are not physically someone being on the other side of a wall and listening in. It is a surreptitious or secret overhearing of another's private words, either by ear or through some artificial assistance, such as a wiretap of some type. Eavesdropping can create civil liability, usually tort liability, or criminal liability. For example, placing an eavesdropping device in a residence is an invasion of privacy. That is a tort claim, and we'll talk more about that in a little bit. You've probably heard of the USA Patriot Act. Usually it's called the Patriot Act. This was a statute that was passed after 9/11 that gave rather large powers to the federal government to investigate potential terrorists and potential terrorist plots. You may have heard of the FISA courts that actually work in these situations. The FISA courts are very secretive courts. They are the ones that issue warrants, and they receive intelligence that oftentimes is very top secret and very sensitive. And so this is the idea. The Patriot Act, it was intended to address what was perceived of as holes in our intelligence system that perhaps allowed 9/11 to occur. And so this was designed to fix those. Very controversial ideas, and people think that they go too far and abridge too many of our freedoms. Others think that they, at least at one point, were necessary, and some continue to think that they are necessary. So, what does the Patriot Act do? It allows the federal government to monitor anyone on the internet simply by contending that the information is relevant to an ongoing criminal investigation. And this can also relate to information that has to be obtained through subpoenas, like cell phone records or things along those lines. The Americans Disabilities Act. This is as we've talked about, the Americans Disabilities Act in another module covers only people who meet one of the three prongs of the disability definition. They have a disability, they have a record of a disability, or they're regarded as having a disability. But there is one section that applies to all workers and applicants, even if that person doesn't fit into one of the three prongs. And that relates to private medical information. So this is the one area of the ADA that applies even to able-bodied folks. And so medical information cannot be kept in the same file as the other parts of the personnel file. So in theory, each employee should have two files, a medical personnel file and a regular personnel file. And if these are electronic files, they have to also be segregated in the electronic world. And so this is a requirement. If there is commingling, even if there is no other violation of the Americans Disabilities Act, that is a serious issue and can result in fines for the employer. This can be difficult because you can have workplaces where there are multiple personnel files. For example, imagine there's a large facility. There could be an electronic personnel file. There could be a centralized personnel file in the personnel office or HR office. And there might be a supervisor may keep a personnel file in his or her office, including just maybe the latest appraisal or that person's goals for the year. And in that file, the supervisor may keep a lot of stray things. The sick note that the employee submitted when he had to be out for 3 days or something like that. And so it's usually at the lowest level, at the supervisory level, that we find that sometimes personnel files are, I'm going to say, contaminated or commingled, that there's medical information as well as performance and other types of information, when really there should be two files along those lines. So it's necessary when you're working with clients to make sure not just the HR department knows that files can't be commingled, but that knowledge extends to the very lowest supervisory level within an organization. We'll talk about the NLRA, the National Labor Relations Act, and OSHA, the Occupational Safety and Health Act, and their privacy issues in later presentations. So now we're going to talk about the common law. The common law is, for most legal professionals, a very sweet spot. It is where most of us spend most of our time working. It is uh, our most important, in terms of volume, source of law in the United States. And in fact, when people describe our legal system, they refer to it as a common law system. And in fact, most countries that were formerly part of Great Britain, and usually you can identify those countries because the primary language is often English, or at least English is a very common language in that country. So we've got Ireland, obviously Great Britain itself, Canada, the United States, India. Um, those are Australia, New Zealand. Those are examples of countries where they have a common law tradition. There are other countries, though, that also fit into that category. And so most countries that were not part of the British Empire aren't common law. We call those civil code jurisdictions. And in those places, judicial opinions don't have nearly the significance or importance in their legal system as they do here in the United States and other common law jurisdictions. So, what is the common law? It's law made and applied by judges based upon precedent, which is prior case law or common law. Now, in our system, of course, we do have statutes, and those statutes are made by the legislative branch. So the judges make common law, the legislature makes statutory law. And we would say the executive branch makes regulatory law. So each one of the branches has a law creation purpose or function in our system. And so the common law is a really important source of law. Now, in this practice area, we've been talking primarily about statutes. But you may recall in the very beginning, we talked about the employment at will doctrine, and we talked about the master servant idea. Well, all of that is common law. So it is also important even to the employment law practice area. We've talked about the public sector. Here's a definition of the private sector. Good to add to your Quizlet. It's that section of the workforce represented by private companies. No big surprise here. Um, these are not government companies. As we've already discussed, there is no constitutional protections for private sector employment. There's also significantly less privacy protection generally for employers. There can be company policies that give some protections, and sometimes those can because of the reasonable expectation notion that we've talked about. Sometimes those can actually give rise to additional rights that the employee has. And then, of course, there can be collective bargaining agreements when the union and the company come together and reach an agreement, and those can provide privacy rights. But usually, especially in Texas, we're not talking about a unionized facility. We've already talked about employment at will, so I'm not going to spend a lot of time on this, but just a little reminder. Unless an agreement specifies otherwise, employers are free to fire an employee, and employees are free to leave the position at any time and for any reason, except for an unlawful one. Again, employment at will is a common law concept. Generally, Texas does not have a state law privacy protection. So, when we're talking about protections for private employers, we're talking usually about those federal statutes that I just mentioned in an earlier part of this presentation, and we're talking about common law protections. And the way that the common law addresses privacy is through tort law. The common law has lots of different areas. There's all the common law about contract law, and there's all the case law, the common law about tort law. And so now, when we talk about privacy issues, we're going to be talking about tort law. So here's the definition of torts. A tort is a private law, a private wrong in which one person, in this case, we're talking about an employer, but it wouldn't have to be, causes an injury to another person, in this case, the employee. So we see torts all the time. A car accident is a tort. And so if you sue about a car accident, you're suing about a tort. If I spread malicious rumors about you and get you fired, you would sue me about a tort. If I spill ink on your very expensive dress and you want to sue me over it, that would be an example of a tort. In Texas, and really, I think throughout the United States, tort law is primarily common law. There are a few statutes that we have, but most of those statutes aren't even applicable to the tort laws that we're going to be talking about. And I would say 90+% of tort laws remains part of the common law. And of course, the goal of the tort law is to fix the circumstances of the injured person, to make him or her whole by giving him or her a remedy through the court system to collect damages. And of course, the injury can be physical. In a car accident, I break my arm. It can be mental. Someone tells lies about me and hurts my feelings. Or it can be financial. Somebody steals my business secrets and makes money that I would have otherwise made if the secret hadn't been stolen. So there are lots of different types of injuries that can happen because of a tort. So the state court systems have invented lots of different theories for how the privacy torts can arise. And we're going to talk about 4 of those. But whenever we talk about them, we're really talking about the reasonable expectation of privacy. That's in the background of all of these different theories. So if the person who's suing did not have a reasonable expectation of privacy in that particular situation, he or she is not going to have a good tort claim. But if he or she did have a reasonable expectation of privacy, there's at least a chance that a court is going to say, yes, we think this person has a claim. They may need more than a reasonable expectation of privacy, but that is at least a requirement for these torts that we're going to be talking about. So the first one we're going to talk about is intrusion upon seclusion. I love this name. It's almost musical, the way it's called. So this is wrongful invasion into somebody's privacy. Obviously, it has to be objectionable to a reasonable person. And again, in this place of seclusion, there has to be a reasonable expectation of privacy. And it has to be the type of intrusion that would be objectionable to a person of reasonable sensitivity. If you've ever heard about paparazzi uh, uh, bothering rock stars or actresses or that type of thing by following them around to places and maybe sending in drones with cameras into their private areas, this would and then the rock star, the singer, whatever, sues about it, they're probably suing under an intrusion upon seclusion theory. And again, here's a little description of about how that theory works. And you can see here it has to be highly offensive to a reasonable person. It has to have been a situation where the person really did think, hey, I'm probably in a private place. So if I'm on the beach, nah, I don't have a right to seclusion if it's a public beach. Even if it's uh, not public, if people can in a from a public place see me in that place, I probably don't have a sense that it's truly private, and I'm going to have a hard time arguing that it's highly offensive for those people who might be seeing me in this location. Let's talk about public disclosure of private facts. So this is intentional or negligent public disclosure of private facts. And again, if you haven't added this term or this term to your Quizlet, I recommend that you do so. So in order to advance this theory, the plaintiff must show that there was an intentional or negligent disclosure of the private facts and that it was objectionable to a reasonable person. So there has to have been a reasonable expectation of privacy with respect to those facts. And again, here is the description of how that would be. You can see here in the formal definition, the matter disclosed was not of legitimate concern to the public. So in this situation, let's say somebody is running for public office. I'll give you an example. This is ancient history, but back in the 80s, a person by the name of Gary Hart ran for president. And while he was running for president, he went on a boat trip with someone who worked on his staff, a very young and attractive woman. And the name of the boat was Monkey Business. And you can imagine what happened on the boat. And so he's in the middle of a campaign engaging in, and he was a married man. He was engaging in behavior that probably his wife would not have approved of. Let me just put it that way. It certainly was on a private boat. It certainly was offensive to him that this matter was disclosed, and the disclosure by the press was intentional. But since this had to do with his character as a potential president of the United States, it was a matter of legitimate concern to the public. So he would not have probably had a public disclosure of private facts valid lawsuit. By the way, as you know, there isn't a President Gary Hart in our history. That monkey business scandal pretty much destroyed his chances to become president. Don't know if he would have become president otherwise, but that was an important factor in him not becoming president. So let's consider this scenario. Mary finds that her Bob and her supervisor keeps in his desk drawer photos of her in a revealing bikini that she wore when they hung out one day at Bob's backyard pool. When Mary sees this, she asks Bob to return the pictures. Bob doesn't. Instead, he emails the pictures to other people. Now, Bob didn't take these pictures secretly. They were at an event, and they were having fun taking pictures. But of course, this was something that Mary certainly did not intend for Bob to share the pictures with coworkers through that type of communication. So, under these circumstances, Mary very possibly does have a public disclosure of private facts type of tort action. Here's another scenario. So, Bob and Mary this time are coworkers. Mary overhears, maybe they share a cubicle together, for example. Anyway, she overhears Bob on the phone saying that he has leukemia. Mary's a gossiper. She tells her coworkers. Bob didn't want the world to know that he had this diagnosis, and so this would be an example of public disclosure of private facts. In this scenario, Bob works in HR. He leaves an employee's private medical files on his desk. The files fall to the floor, the papers fall out. Information about the employee's AIDS diagnosis are visible. Some employees see them, and the word gets around the office that this particular worker has AIDS. In this situation, even though Bob did not intend for any of this to happen, he was negligent in how he maintained the records, and so he would be guilty of public disclosure of private facts. Let me pause here and say that um, Bob individually would be guilty, but because Bob was having this record in his capacity as an HR manager or perhaps as a supervisor, the employer would also likely be guilty. In this situation, because these two individuals are coworkers, Mary would be guilty of public disclosure of private facts, but I think it's relatively unlikely that the employer would be guilty. In this situation, because Bob is the supervisor, obviously Bob is guilty of the public disclosure of private facts, and very likely the employer is also guilty, especially if Bob used the company email system to send the pictures. We have another scenario here. Larry was upset with Bob, his supervisor, for giving him a poor performance appraisal. Larry posts a copy of Bob's criminal record, and apparently Bob has gotten into mischief on the employee board in the cafeteria. In this situation, Bob doesn't have a good case because criminal records are public records. But if let's say that Larry had posted copies of documents from Bob's divorce, and let's say those records had been sealed, well, then under that scenario, Bob would have a case for public disclosure of private facts. So the problem here is that they are not really private facts when they're criminal records. Now, this doesn't mean that Larry, even though Bob can't successfully sue Larry, doesn't mean that Bob can't fire Larry or demote Larry or take other disciplinary action. Again, Larry is employed at will under these scenarios. Let's say that Larry had posted again those sealed documents from the divorce proceedings that Bob went through. Um, Larry certainly would be potentially liable for the public disclosure of private facts, but because Larry actually reports to Bob, it's very unlikely that the employer would be responsible under those circumstances, unless somehow Larry got those records through his employment somehow or another. So Lucy works for a religious bookstore. She had an abortion several years ago. Mary finds out about that fact and she reveals it to coworkers. And the coworkers start mistreating Lucy because they disagree with her decision to have the abortion. Under these circumstances, Lucy could sue Mary for public disclosure of private facts. Again, because Mary's a coworker, not a supervisor, probably Lucy would not have a good case for a religious books against the religious bookstore. It's possible, though, if Lucy brings that to the attention of the religious bookstore and the religious bookstore doesn't address the ostracization that Lucy is experiencing, there may be some kind of uh, uh, possibly sexual harassment angle to this type of situation. So there could be some claim lurking there if the religious bookstore doesn't address the problem once it becomes aware of it. Placement in a false light. This is public disclosure of facts that place the employee in a false light. Imagine the Dallas Morning News having a picture of Bob in handcuffs. You can see the handcuffs. He's holding up his hands and he's got the handcuffs on it. And below it says, um, man indicted for treason. Well, it ends up that Bob was the person who ratted out Larry, and Larry is the person who's guilty of treason. And the only picture that the newspaper could find of Bob was at a Halloween party where Bob had pretended to be somebody. Bob's wife was the sheriff, and Bob was the criminal that was being carted away to jail. But certainly, that picture implied to someone looking that Bob was the person who committed treason, and that, especially the handcuffs and just even having the picture there, would certainly suggest that. Even though when the person reads the article, it's clear that Bob is actually the hero in the story. He's the one that found out about the treasonous plot and saved America. But the facts, even though they're not misstated, put that person, in this case Bob, in a false light. So what do we need to prove to advance a prima facie case of a publication in false light? Well, there has to be a public disclosure of facts that put the employee in a false light before the public. Obviously, it has to be highly offensive to a reasonable person, and that the person who provides the information must have known that that would have that implication. So here, Lucy openly talks to her coworkers about her romantic shenanigans with certain clients of the firm. Um, Bob, Lucy's supervisor, hears about this, and he talks to her about, hey, engaging in this behavior can harm the reputation of the company. If one of these relationships goes astray, we may lose that client as a customer. And Lucy feels like, well, when the senior officials in the organization hear or see this performance appraisal, they will think less of her. But in this situation, no, Bob has not committed the tort of publication in false light. It seems that he has accurately described what Lucy has done. And so, if it's accurate, if it's not misrepresentation or twisting of the facts, then there is no false light publication. An appropriation of a name or likeness would be if an employer uses the uh, uh, name or likeness of an employee without his or her permission, say in an advertising campaign or something along those lines. Now, of course, an employer could say, we're going to use your picture. Do you agree? And the employee could say, well, no, I don't agree. And then the employer could say, okay, we won't use your picture, but I'm firing you. So certainly at that point, the employee might say, well, kind of give it another thought. I might be okay with you using my likeness under these circumstances. And in addition to privacy situations, we can also have a breach of contract that can arise in a privacy context. And we also have intentional infliction of emotional distress, which can have potential privacy claims. When you have an intentional infliction of emotional distress, the defendant, the person who's being sued, has to have intended to harm, and the behavior has to be extremely outrageous. And it does have to actually cause severe emotional harm. So if I were to tell you a joke, or I'm playing a prank on you, it's April Fool's Day, for example, and I say, oh, I just saw on the news that your whole family was killed in a terrible car accident. You must feel terrible right now. And the person believes me. Oh my gosh, I had no idea that happened. When in fact I'm pulling a prank on them, that could be considered intentional infliction of emotional distress. So here's a list of how Texas responds to the 4 torts that we just talked about, the invasion of privacy torts. The appropriation tort, which was the last one we covered, the reasonable intrusion upon seclusion, the public disclosure of private facts, and the false light. So let's see what we do in Texas. So the appropriation of a likeness is a legal theory that Texas recognizes, and I've given you the Texas Supreme Court case that talks about that. Then we have the unreasonable intrusion upon seclusion. Again, Texas also recognizes it. It's in the same case. Texas, though, has declined to recognize the public disclosure of private facts. That is not a tort in Texas. Texas probably recognizes the false light claim. It's not as clear in Billings as the other 2 claims are. So we have a yes, a no, and a probably. And by the way, you can find these 2 cases on Canvas if you're interested in looking at them more closely. Okay, so let's talk briefly about defamation. Defamation isn't quite a privacy theory, but it's kind of related, and I think it's helpful to pause for a second and talk about that. So defamation is an umbrella term. There are 2 categories within the umbrella term. Let me actually go forward for a second and talk about that. So one of the 2 terms under the larger umbrella, one is libel, not just 2 syllables, libel. And this is defamation in a written document. This is the more serious form of defamation. And the way I remember it is with the L's. Libel starts with an L, If you remember lasting letter, that helps you remember it's in a written form. Now, technically, libel doesn't have to be written form. So let's say someone posts something on the internet, maybe a YouTube video. Well, that would count as libel because it's lasting. It doesn't go away. Like if I say something verbally to somebody, if it's not being recorded, that action is completed in a few seconds and it's not continuing to occur. But if somebody tapes me saying that and then posts it on YouTube, in some sense, the libel is continuing on indefinitely. So this is the more serious matter. So here's an example. A manager gives false defamatory information about a former employee through an email. That would be libel. So slander is the spoken part. Again, we see that slander starts with an S and spoken obviously starts with an S. And this is obviously defamation that is oral. This is the less serious form. A manager gives false defamatory information about a former colleague through a telephone call. That would be slander under those circumstances. So let's go back and talk about defamation. So, what do we have to prove for both types of defamation? Well, of course, the first thing that has to be proven is that whatever was said was false. Um, and if it's true, it can't be defamation. The second thing is that it has to have been communicated to a third party. So if I say something to you about you, I can't defame you to you because you know whether it's true or false. It's only when I tell a third party that it becomes the possibility of defamation. And we call that publication. But publication is kind of a misleading word because it doesn't have to be published like a book. Again, me saying it to another person counts as publication. You may have heard earlier in the course that we talked about self publication, where an employee who was, say, dismissed from his position goes to a job interview. The potential employer asks him, well, why did you leave that previous job? Well, the employee has to self publicize, in other words, tell the potential employer the reason that the employer gave. Now, the employee can say, that's not true, I didn't really steal, but the potential employer is probably likely to be suspicious of the employee at that point and not continue considering that person seriously for the position. And then finally, there has to be harm to the employee. Uh, and we're not going to go into great detail about what the types of harm that can be. So these are the elements to establish that prima facie case. Let's consider a scenario. Lucy was fired by Eager Beaver Mart because she stole from the cash register. So she actually did this. A police report was filed. A prospective employer calls the mart for a reference, and they're told, well, Lucy stole from the cash register. So, what uh, the prospective employer was told is true. If it's true, it can't be defamation. Let's consider Bob's scenario. So, Bob was employed at the bank. He left the company voluntarily after he ended a personal relationship with someone there, a romantic relationship. When a prospective employer contacts the bank, Mary, Bob's former romantic partner, tells the prospective employer that Bob was fired for misconduct. That's a false statement. So we have a falsity and we have publication right here. And we even have harm to Bob because Bob doesn't get the job. So we have all three of our elements present. So under these situations, Bob would have a cause of action for defamation against Mary individually, but because Mary is the agent of Farmersville City Bank, against Farmersville City Bank as well. And here we have the concept of compelled self-publication. Again, if you don't have this yet in Quizlet, be sure to add it. When an employer when an employee, sorry about that, when an employee is left with no choice but to tell a prospective employer the defamatory reasons for his or her discharge from, a past employer. We in Texas do not recognize this claim, and I don't think that this is recognized in very many states. Um, Vermont is one that apparently does recognize it. I've seen a case from that jurisdiction. And I'm not going to say that there aren't several other states, but it is a pretty far extending doctrine. It's a pretty stretched doctrine. I don't think there are very many courts that would find this a very compelling legal argument. But again, if you are representing clients who do business in other states, it would always be a good idea to be aware of what your particular state's laws are about compelled self-publication. And if that jurisdiction does recognize compelled self-publication as a potential tort claim, then it may, in some ways, affect how you communicate and what words you use to communicate the dismissal decision. Let's consider this scenario with Bob. So Bob's accused of misappropriation of company funds. He vehemently denies it. The company fires him without having any proof. He applies for jobs, and when he applies, they ask him, "Why'd you leave your other place of employment?" And he has to respond to the respective employers with a reason he was fired. Yes, he tells them that he denies it, but they're going to say, we don't want to invest in a guy that may be stealing from us in the future. So, under these scenarios, if Bob is in a jurisdiction that recognizes compelled self-publication, he may well have a claim against his former employer, but it's not going to work in Texas. So, in Texas and also many other states, I would say probably most states, an employer has a privilege with respect to making statements, even if they would otherwise be defamatory, where the statement is made in good faith by one who has a legitimate business reason to communicate to another about that information. And I'm going to show you the statute in just a second. Let's unpack this for a second. Organizations, it's a social good for organizations to be able to communicate freely with various stakeholders when regarding HR matters. So let's go back to the facts that we had here. Bob's accused of misappropriation of company funds. Um, let's say that instead of the company firing him without any proof, it conducts an investigation. And so there will be witnesses who give information. And these witnesses will have different perspectives. Some probably think Bob did do something wrong. Some probably don't think Bob did do anything wrong. You can imagine how chilling it would be in an organization if anyone who wanted to criticize Bob could be facing the possibility of Bob suing him or her individually. No one would be willing to give any information. And so the company would never hear about wrongdoing. Well, that wouldn't be good for the company. It wouldn't be good for the company's clients. It wouldn't be good for the company's shareholders. It's good for the company to be able to investigate people for sexual harassment, for stealing, for whatever the issue is. And it makes sense to assist the company in engaging in that type of investigation. And so this type of protection is part of that protection. Sometimes employers give job references for individuals, and we've already talked about this in previous lectures, but I want to touch on it briefly here again. And that is that an employer who gives a reference, either a written form or a telephone reference to somebody, um, uh, may say something that uh, is going to cause this prospective employer not to hire this particular worker. And so it could be that whatever was said, the person who made the comment was mistaken. He got his Bobs confused. He's had lots of Bobs work for him. There's a lot of turnover in this position. And he thought that they were calling about Bob Smith when in fact they were calling about Bob Green. And he just got his people confused. Well, it's a useful idea for companies to be able to share information about workers. That way, people who engage in sexual harassment, for example, won't move from employer to employer and continue disrupting people's lives through continued instances of sexual harassment, for example. Or imagine a daycare center where you had an employee who uh, did not keep safe conditions for the children, uh, did not maybe was hit a child or something along those lines. You would want all other potential daycare facilities to be able to find out about that so they didn't inadvertently hire somebody who could be a danger to their children. And so having a way for companies to share references that provide some level of protection for them against lawsuits is seen as a socially useful thing. Now, it is not a complete protection. We'll see in a second when I show you the statute. So, as a result, most employers still choose not to share references, at least most sophisticated employers. Um, that's the safest course of action because, after all, there's really nothing that the company is gaining by giving the reference. And even under the statute that I'm about to show you, there is some level of risk for that particular employer. So let's consider this scenario before we look at the statute. So Bob is employed by Aardvark Industries. After a thorough and fair investigation, he's fired for sexually harassing a secretary. A prospective employer calls Aardvark Industries for a reference, and he was told that Bob was terminated for sexual harassment. Let's assume that the prospective employer doesn't hire Bob. Because the statement is true and it was made in good faith, there is no problem, there is no defamation. Bob cannot successfully sue. But even if it were not true and the person taking the call just got his Bob's confused, but it was made in good faith, then very likely Bob still wouldn't have the best type of lawsuit. Let's look at the statute before we go ahead. Here we have an employer may disclose information about a current, I'm sorry, this one here. An employer who discloses information about a current or former employee under this statute is immune from civil liability for that disclosure or any damages proximately caused by the disclosure unless it is proven by clear and convincing evidence. So this is a higher standard than preponderance of the evidence. Unless it is proved by clear and convincing evidence that the information disclosed was known by that person to be false at the time the disclosure was made, or the disclosure was made with malice or in reckless disregard for the truth or falsity of the information disclosed. So this is our safe haven in Texas for reference checks. So at this time, we've covered in our first lecture a general introduction to the topic of privacy. We just introduced the concept of the reasonable expectation of privacy. And we did most of the discussion of constitutional issues related really to government employment. In this presentation, we talked about concluded the constitutional issues related to government employment. We talked about the federal statutes that apply to both federal, state, local, and private employment. And then we talked about the common law issues, and this is the main area that employees have protection. In future presentations, we will finish the module and talk about these additional topics. I hope that this presentation has been helpful for you. If you have any questions, please feel free to stop by my office hours and we can talk in more detail about it. Thank you for your attention. Have a wonderful day.